afternoon. Before Mr. Hibner calls the case, I want to cover a couple of things. One, wanted to thank the lawyers and their clients for agreeing to this process. A remote hearing like this has enabled us to continue the work of the Court of Appeals, which benefits people in the state of Tennessee and, of course, your clients as well. If we should have a tech problem, don't worry about it. We'll take a pause, and Mr. Hibner and the AOC's IT people will be able to resolve it. So far, they haven't had any they couldn't resolve. They've pretty much worked it out, so we've avoided most of them. Call the case, please, Mr. Hibner.
Debra A. Irvin versus Greenwise Homes, LLC, et al.
We'll hear from the appellate.
Okay. Good afternoon, Your Honors. My name is Charles Walker, and I represent the appellant. I would like to reserve 5 minutes for rebuttal.
That'll be fine.
Okay. I raised 3 issues in my principal appeal that was filed, and those issues were, of course, then brief. But just briefly, the first one was the trial court had erred by denying Greenwise Homes voluntary non-suit without a showing of plain legal prejudice by the other parties. And the second one involved TCA 2012-119, which is the assessment of attorney fees up to $10,000 when a motion to dismiss is filed and granted. That's what issue 2 dealt with. And then issue 3 was a rather unique issue where there were pleadings that were filed in the United States Bankruptcy Court. And then those pleadings became the subject of the application of that very statute, TCA 2012-119C. So that issue's been raised of whether the trial court could apply that statute to pleadings that were filed in the bankruptcy court. So briefly, let me tell you all about the case just a little bit so you know what's going on here. This involves a tax sale property. And Miss Irvin filed a lawsuit against numerous people, a couple LLCs, 2 or 3 individuals, me, myself as an attorney, claiming that she was somehow defrauded out of her property that she lost at a tax sale. Miss Irvin had sold her right of redemption, which I don't want to get it super technical with the court, but basically when your property is sold at a tax sale, you have a year to redeem it. During that year, right before it was up, she had sold it to a company by the name of REO Holdings, which was not named in this lawsuit. She claims that as a result of that sale, she was unable to claim her excess proceeds, which she claimed would have been $70,000. She admitted that she had mortgages on the property that were in excess of $250,000, far in excess of the excess sale proceeds. Anyway, she filed this lawsuit claiming that she was entitled to upwards of $850,000 in damages. When she filed this lawsuit, she filed a lien lis pendens against all of the property that Greenwise Homes LLC owned. And that property, as the trial court had found, was valued, according to the plaintiff's own estimates, upwards of $2 million, $3 million, far in excess of what they were claiming. So the lawsuit wasn't long after it was filed till it was removed to the federal court, the federal bankruptcy court. While it was pending in the federal bankruptcy court, Greenwise Homes filed an answer to her complaint. And they also filed, for the purposes of this appeal, they filed other things, but for this appeal, they filed a counterclaim against Miss Irvin, the plaintiff. And they claimed that she wrongfully asserted that lien lis pendens against the property and that they suffered damages as a result of that.
And I'm sorry for interrupting you, but that's ultimately what the trial court dismissed, was those counterclaims, because Ms. Irvin, if I understand the record correctly, she voluntarily dismissed her claims That left the counterclaims, and in particular for this appeal, the counterclaims that Greenwise made. A motion to dismiss was filed. That was granted. You're not challenging on appeal the substantive decision the trial court made with respect to granting that motion to dismiss. You're challenging the fact that the trial court did not allow you to voluntarily dismiss those counterclaims after he had made his oral pronouncement, and then also the issue of the attorney's fees under the statute.
Correct. And Greenwise Homes, just for the record, made one claim against Miss Irvin there in the counterclaim. So there was one claim against her, and that claim was dismissed at the trial court. That motion was granted.
Right.
And so my argument on this, and the reason I was telling that brief history on it, was because when Miss Irvin, when I filed a motion on behalf of Greenwise to remove this lienless pendants, saying there was no basis at law for it, and it was basically a frivolous lien, the trial court did find there was no basis at all, and it was an improper lien, and they removed it. I copied the order, it's in the brief. When the trial court made that ruling, it wasn't very long, just basically practically minutes after the trial court finally denied her motion to revise, that she non-suited the case. So she non-suited her claims actually before I made it back to my office.
But none of that is the subject of this appeal, correct?
No, I just wanted to point that out to the court. She'd done that. Now, then we, after the motion to dismiss was granted by the court, I filed on behalf of Greenwise Homes, I think it was 3 hours later, a non-suit with the court for the very claim. So my argument to the court is that when the non-suit's filed, the general rule in Tennessee anyway on the non-suit is that it's going to be granted unless there's some showing, and I'll quote it here, that there's some showing of some kind of plain legal prejudice. So the general rule is that it should be granted. And I do realize this is reviewed under an abuse of discretion standard. In Hamilton v. Cook, that's what the judge would review, or the court would review it under. But the court still has to have the elements. There has to be some showing of plain legal prejudice. Now, the claim that Greenwise Homes was asserting against Miss Irvin, the trial court had ruled was baseless, and it was dismissed. The claim for damages that was filed by Greenwise that was ultimately dismissed, while we're not challenging the ruling of the court, this appellate court has ruled before in Lowe's v., and I cited it in my brief, Lowe's v. First City Bank, the court had recognized damages for wrongfully asserting a lienless pendants against someone's property. But we're not raising that. I'm just pointing that out for purposes of showing the four factors of there was no legal prejudice to the plaintiffs when the non-suit was taken. There certainly was no right there.
Mr. Walker, let me jump, if I may, to the issue of attorney's fees. You're challenging the court's, what you contend was the court's decision to award attorney's fees under the statute 20-12-119C, and you're claiming those are fees that the court awarded against Greenwise as to Ms. Irvin, as to the claims it made against Ms. Irvin. So those are claims to Ms. Irvin.
Correct.
Here is my question. I cannot find anywhere in the trial court's order where they specifically make an award of fees to Ms. Irvin. If you look in the court's order, I think it's 596 and 97 of the record, the trial court talks about attorney's fees, and it goes through, it says, the court grants third-party defendants their reasonable attorney's fees incurred in responding to Mr. Walker's counterclaims. They go on to talk about Mr. Johnson, and they say the court respectfully denies third-party defendants' motion for attorney's fees against Mr. Johnson. Then they say Greenwise was represented by counsel. Court determines that third-party defendants' reasonable attorney's fees and expenses incurred in responding to the counterclaims are awardable. Then at the conclusion, it just says, court grants the motion to dismiss filed by Ms. Irvin and third-party defendants in their entirety. Attorney fees are available under the statute as provided for in this final order. What I can't find in the order is where it specifically makes an award in favor of attorney's fees in favor of Ms. Irvin.
Mm-hmm. There is no dollar amount that's been awarded yet.
Not even a dollar amount, just a statement that Ms. Irvin is granted her attorney's fees. I know there's no dollar amount for anybody, but I can't find where he's actually awarded attorney fees in favor of Ms. Irvin.
I don't know if it was actually used as he used the word attorney fees. I think it was costs was the word that was used in that order.
Okay.
But cost was defined in the statute to include court costs, attorney fees, court reporter fees, interpreter fees, guardian ad litem fees. I don't think they had any of those, but that's what I was going off of, was that the trial court had made an award. If I look at that statute, that 2012-119 that awards them, part 3 says that the award of costs pursuant to this section shall be made only after all appeals of the issue of the granting of the motion have been exhausted. Mm-hmm. And the final outcome is the granting of the motion to dismiss.
Thank you.
Your time's expired. You have your time for rebuttal. Let me ask the appellees, is there going to be more than one argument from the appellee side? You're muted.
Your Honor, this is Paul Krogh on behalf of Mrs. Irvin. I'm going to handle the bulk of the argument. I'm like to reserve 30 seconds for Ms. Spohr to field questions and make any sort of joined announcement she'd like to make.
Let's give her a minute. 30 seconds is just about time, impossible to even get a question out. So
that's perfectly fine, Your Honor. I'm happy to accommodate the court in that respect.
Okay, so you've got 14 minutes then, right?
Thank you, Your Honor.
Fine.
Mr. Hivner adjust the clock. He did adjust the clock. Thank you, Mr. Hivner. Very well. Well, it pleases the court. My name is Paul Krogh. I'm here on behalf of the counterclaim defendant, Mrs. Irvin. And there are 4 issues we might talk about maybe today. And I'd like to start, I think, sort of where Judge Davis, where you left off, which goes to really the appealability issue that we've raised with respect to this appeal. So Judge Davis, not only are so the fees aspect of this obviously is not final. So not only is there no, there's ambiguity in the order perhaps about who is entitled to fees, but the fees order isn't appealable at all because it hasn't been liquidated. And this court has been very clear in the past, for instance, in the Solomon case from 1989 and the E-Solutions case more recently, both along with other cases cited in our brief, that when there's attorney's fees at issue in a case, but the court doesn't liquidate that award, doesn't say you're entitled to X dollars, then that's not a final order and it's not appealable.
But excuse me, Mr. Krogh, none of those cases deal with the statute that we're dealing with here. And that statute specifically says that the actual dollar amount, the award, doesn't take place until all appeals have gone through the appellate process. So
Correct.
To me, the issue is not that. The issue with respect to attorney's fees is, did he even award attorney's fees to Ms. Irvin? I don't find it in there.
Well, yeah, that certainly hasn't been raised as an issue by Greenwise in the appeal. And I think the whole fees issue is still inchoate and non-final. I think the trial court did exactly what in a state of hair last year's Supreme Court case, and it's actually just a footnote about this issue. But the footnote, the state of hair, says that when you grant that motion to dismiss, the best thing for the trial court to do is certify the dismissal as final under 54.02, and then that leaves the attorney's fees award under that statute, under 119C, that leaves that as sort of a standalone claim that remains non-final, and then that can be wrapped up after the appeal from the 54.02 merits judgment is resolved. And so I think the whole fees issue here, if you look at a state of hair and you look at this court's existing attorney's fees jurisprudence, the whole attorney's fees issue is really premature because it hasn't been liquidated, and we're going to go back down and that's going to be liquidated, and then we'll have the whole appeal.
What I'm saying is the statute says the exact opposite. It says it doesn't have to be liquidated and that it shouldn't be liquidated until it goes through the appellate process.
I'm not sure I have picked up on that particular nuance in the statute. I know that it says that it's supposed to await.
Here's what it says in C3. An award of costs pursuant to this section shall be made only after the appeals of the issue of the granting of the motion to dismiss have been exhausted. And if the final outcome is the granting of the motion to dismiss, the award of costs and attorney's fees pursuant to this section shall be stayed until a final decision, which is not subject to appeal, is rendered.
So I think that supports our position, Your Honor, that the attorney's fees issue is not right. That under C3, certainly the court doesn't even have to make any ruling about the attorney's fees before the merits appeal is exhausted. The trial court could have left entitlement and liquidation until afterwards. And the fact that it entered an order specifying at least partially with respect to entitlement doesn't make that proper for appeal before we've settled whether there is or is going to be an appeal on the merits. So I think our argument about this issue being premature is entirely consistent with the provision Your Honor was pointed to in C3. We don't think really that the merits appeal is appropriate at this juncture either, because the post-motion, the putative Rule 59 motion that Greenwise and Mr. Walker filed after the 54.02 final judgment only directed itself to that attorney's fees issue. It didn't complain about or ask for a revision of the merits dismissal. And this court has said, for instance, in the Guest House case from about 10 years ago, that the sort of obvious conclusion is that when you have a Rule 54.02 certification, it doesn't make the whole case final. It only applies insofar as it says it does and insofar as it can under the rule. So if you file a motion asking the judge after a 54.02 final judgment to fix something that's still interlocutory, that's a Rule 54.02 motion to revise. It's not really a Rule 59 motion to alter or amend. And because Rule 54 motions aren't referred to in Appellate Rule 4, they don't toll the time to appeal the final judgment. And that's a somewhat unusual circumstance, but there are a lot of federal court cases applying this analogous rule that say that those Rule 54 motions to revise don't have any tolling effect. But if the court reaches the merits on either issue, it should affirm easily. With respect to the non-suit, it wasn't just that Mrs. Irvin or the third-party defendants had potential defenses. They had established a defense. They had won. We had won. And you can't take a non-suit after you lose. That was the law readily established in 1978 when this court decided German versus Nicopolis in a directed verdict context. And it was the rule in 20 years later in 1998 when the court decided the Hamilton case. So, and it's something that everybody knows so intuitively that doesn't even come up very often, because no case would ever be disposed of on the merits if you could stand up after the judge ruled from the bench and say, well, I'd like a non-suit, Your Honor. Because everybody would do that. I would do it every time. Who wants to lose when you can take a non-suit and try again? And so Mr. Greenwise says that, well, there's no legal prejudice. If being deprived of victory, of losing the status of having won, isn't plain legal prejudice, I don't think prejudice exists. The court finds prejudice in all sorts of circumstances where events make it harder for a party to win. Here we've got a party, 3 parties, that had won. And then you've got the non-suit, and there's no right to a non-suit in that context, and the Chancellor Perkins was entirely correct to deny that the way he did. As for the fees issue, Your Honors, we've talked about the fact that we think that issue is premature, but even if it isn't, the arguments that Greenwise raises are not meritorious. The argument about the federal court origin of this pleading, that issue is waived. Greenwise, that argument was available to Greenwise when we moved to dismiss, and it shows up for the first time in their after the fact motion to alter or amend that motion to revise. And this court has held on numerous occasions, including the Central Parking Systems case from 2010. It was a Western Section panel hearing a Middle Section case, and the NRA MLD case, that you can't preserve an argument for appeal by raising it for the first time in a motion to alter or amend, not if it was available beforehand on the initial motion, the initial order. And those are Rule 59 cases, but Supreme Court in Harris versus Churn, as this court knows, says that when you assess those motions, it's basically the same standard. And certainly Greenwise filed its motion as a Rule 59 motion. We've argued it was truly a Rule 54 motion. I think in either context, they're not allowed to wait until after they've lost to raise an argument for the first time and then have it preserved on appeal. The case law prohibits that. And even if the argument were preserved, it's not the law anyways. They say that the court can't impose that fee shifting award on a pleading filed in federal court. They cite some federal intermediate appellate court and trial court cases of that principle. None of those cases apply. They're all applying the text of old versions of the Federal Rule 11. And the Supreme Court of the United States has said that no, even if that is a sanction, assuming that's a sanction, you can be sanctioned for things you do in other courts that are connected with the present proceeding. That's the Chambers case, and then there's the Western Systems case, both of which are cited in our brief. And obviously, once the pleading was before the Tennessee court, the chancellor was going to apply the Tennessee rules. That's the only thing it could apply, and that's the Tennessee Supreme Court Cooper case that's cited in our briefs. The federal rules no longer apply to it. There's the question of timeliness of the motion itself, which Mr. Walker didn't talk about in his presentation, but is heavily present in the papers. Greenwise takes the position that the stay that Chancellor Perkins put in place basically was a Rule 6.01 set of circumstances that made the clerk's office inaccessible. I think that's plainly inconsistent with the terms of Rule 6.01, because that says whether or other circumstances make it inaccessible. And that wasn't what this was. This was a stay that put the case on ice, like the stay in the Convalinka case, and told the parties don't do anything else. And what that really does is the certainly more sensible rule is that a stay of that kind tolls time periods. And we've cited several cases in the briefs, actually in the brief filed by Ms. Spohr, for the principle that removal stays state court deadlines, that the stay does. And there are other cases from other state courts that say that stays in general operate to toll deadlines and time periods. They don't render a clerk's office inaccessible for the equivalent of Rule 6. And just to point to two, would be the D.R. Horton versus 8th Judicial District Court case. It's 131 Nevada, 865, Nevada Supreme Court case from 2015. And the Briggs versus Farmers Insurance Exchange, 233, Wisconsin 2nd, 163, Wisconsin Court of Appeals applying a Wisconsin Supreme Court case. So regardless of whether you count the days from remand or from the lifting of the stay, you don't get to 60 days from the time either of remand or the filing of that Greenwise counterclaim when you told the time period for the stay. And with respect to another issue about the origination in federal court, that's not what the statute says. The statute doesn't say a pleading that is filed in a state court. Obviously, sometimes pleadings get filed in federal courts and they wind up in state courts. That's not unusual. The statute says when the state court grants the motion to dismiss, and that's what it did here. We've also raised as a sort of protective cross issue the trial court's denial of fees with respect to Mr. Johnson. And again, we think that's something the court doesn't need to reach because the fees issue was not final. But if it does, we think the court should reverse that, because I think if you look at Mr. Johnson's pleading, it was objectively unreasonable. Essentially, the same standard is set out in the statute as the court would apply under Rule 11. The trial court didn't make a particular finding about why Mr. Johnson's conduct was reasonable. So we think that's going to be de novo review under Kelly versus Kelly, this court's 1984 decision. Unless the court has any other decision, any other questions, we'd urge affirmance and yield my time to Ms. Spohr.
I hear none. Thank you. We'll hear from counsel.
Good afternoon, Your Honors.
Yes, sir.
May it please the court. My name is Caroline Spohr, and I am representing Mr. Krogh and then Eugene Bulso, the third-party defendants in the Chancery Court below. We're in a bit of an unusual situation because my clients are also my co-counsel in this case. Your Honors, we would adopt Mr. Krogh's arguments and rest on our briefs. I did want to make one small clarification. Greenwise argues for the first time in its reply brief that the third-party defendants don't have appellate standing in this case because Greenwise didn't raise any issues in its opening brief as to the third-party defendants. Greenwise filed both a counterclaim against Ms. Irvin and a cross-claim asserting the same wrongful assertion of a lienless pendants claim against the third-party defendants. So they are parties to this action. They were parties in the Chancery Court, filed a motion to dismiss, and under Rules 3H and 13A, they were obviously permitted to participate in this appeal fully. They did not need to file a separate notice of appeal to confer appellate standing. So if this court, unless the court has any questions, we'll rest on our briefs and adopt Mr. Krogh's arguments.
I hear none. We'll hear from the appellant in rebuttal.
Okay, I had to take myself off mute. The reason that I raised that issue in the reply brief, I did not know that the appellees were going to try to participate in the appeal since no issues were appealed against them. And especially to the extent of wanting to raise issues with the trial court to have their decision affirmed, which this court has always said you can't do that. You can't take an issue with the trial court's opinion that you want and then seek to have that affirmed by the appellate court, because it really has the same effect. If you don't appeal it, it's a final order. So that's what I'm saying with this is basically you don't need to come in and argue your issue twice because you're both on the same side. You need to raise a legitimate issue if you and be an aggrieved party, some issue that you want to appeal, not just come in and say, hey, the other side's right. You should affirm the trial court. So the other issue that I wanted to get to, talking about aggrieved party, counsel Mr. Krogh raised the issue about, well, was there prejudice to Ms. Irvin? If we look at the case in the Hudgens case that was cited in my brief about aggrieved parties, a party is not aggrieved by a voluntary dismissal or a non-suit. In fact, their own client took a voluntary dismissal and non-suit the very day of adverse ruling against them, dismissed their whole case. So I'm not sure basically where that argument was going about what prejudice they've suffered when they're not even an aggrieved party. They couldn't even appeal that issue. So wanted to point that that part out. And the other issue is with a 60-day window. I briefed this issue in the brief itself, but the 60-day window under TCA 2012-119, see, that 60 days is 60 days to file. So the operative wording is that the motion to dismiss was filed within a 60-day window. It doesn't have to be heard, and the judge could stay it for a year or two, or ever how long they wanted to. It's just the filing of it, just like the lawsuit. You might file your lawsuit the day of the statute of limitations. It might not get served for months. The court might not hear the case, the jury trial, for 10 years, but that's fine. You just have to file it like it says file. And because this is in derogation of the common law rule, you have to strictly construe that 2012-119. And there's just nothing in there. If you look at the counting of the days, the 60 days, it doesn't say you get 60 days, full days to file this. And if these days are a weekend, or we're not having court this day, or whatever, it doesn't count. So I was using Rule 6.1 to show, well, if the clerk's office was inaccessible, then that does move it to the next day if it was inaccessible for some reason. But Miss Irvin herself had been filing things all along. As I noted, she filed numerous motions during this stay that the court, or that's been referenced. And the stay was issued by the Chancery Court after the case was removed to the bankruptcy court. So the case was removed over to the bankruptcy court, and the order that was entered in the bankruptcy court was that no parties had to respond to the motions that were filed unless the judge ordered it. And this was the judge in the bankruptcy court. So I would submit that the stay was issued in the Chancery Court after it had already went over to the bankruptcy court. So whatever happened in bankruptcy court, that's what we were under. So I would ask that the court count, the way I counted it is pursuant to the Rule 6.1, and the last day she missed that. She had 11 full days in which the stay had been lifted to file that, and she didn't. So I would ask that the court look at that issue, that it was filed outside the 60-day window. And then for the other arguments, I would rely on the briefs that I filed and the issues supporting that. And thank you.
All right. Thanks to counsel for both sides for your argument and your briefs. Mr. Hivner, if you'll adjourn court till tomorrow morning.
This honorable court is now adjourned. Counsel, you may leave at this time.